So, good morning, everybody. I guess it's time for us to resume and start again this morning with a very interesting panel. We have 6 papers this morning. And again, we will engage with more fiascos and debacles. I would like to take this opportunity to thank the organizers for this very, what has been up to now, very friendly and intellectually stimulating conference. I'm happy that we continue then digging in this archive of international adjudication. And I think, as we've seen yesterday, it's not just an archive of past illusions, it's also an archive about current nostalgia and what is brought back to our memory today, and a story about the continuous reinvention of a legal tradition of international adjudication. So again, it's not just about the past. I think it has been made clear yesterday, and I think all the papers in a way show that this morning. The archive provides an arsenal, in a way, for current debates, for current controversies about possible and desirable futures for international law. And this morning we explore another folder, in a way, of this archive, which it's the very rich folder of regional and sub-regional integration systems. And so we will travel from Latin America to Africa and Europe. Of course, in that particular part of the archive, not all experiments stand equal, in a way, and I think the papers will show that. The fact that the European Court of Justice, European courts have come to become, in a way, a model for exports, a point of reference, to a point that actual predecessors to the European Court of Justice have been forgotten or have been, in a way, overshadowed, in particular in Latin America, but also in Africa, as we will see in the papers. So, but I think it was a very good idea of the organizers to start with precisely that institution, which is arguably the success of international adjudication, the European Court of Justice, and actually apply the same questions to that particular court and question whether it is actually the success it pretends to be. Of course, it's a rather unlikely candidate for failure, but I think Henri de Ville, who's a professor of international and European law in Nijmegen, will actually make the case. So I'm very curious to hear him about this criticism of all that is not working, or all the hopes that have not been met, in a way, up until now in Luxembourg at the European Court of Justice. So the floor is yours.
Merci, Antoine, or thank you, Mr. Chair, in all politeness, for this wonderful introduction, and good morning, of course, to all of you. Like others before me, Antoine included, I'll be the first good boy and thank indeed the organizers, in particular Lorenzo, for inviting me. I've said it already and I'll say it again. It's truly a great pleasure to be here at this wonderful gathering in Luxembourg. Here in Luxembourg, indeed, where my topic, the Court of Justice of the EU, is, as it happens, just around the corner. And perhaps this is a very strong invitation for me to mince my words, for any too critical comments might easily be picked up by the persons concerned, perhaps already through the air. I've already understood some representatives of the court are actually here with us today. So it's a bit of a lion's den. Yesterday we saw on one slide hic sunt leones. Yeah, let me stress, therefore, I'm somewhat playing the role of a devil's advocate, or in today's world, maybe a bit like one of Donald Trump's lawyers. Talk about devil's advocates. Now then, not to mince my words prematurely, but really in all academic honesty, let me first press the point that with regard to the court, we cannot genuinely be speaking about a debacle here. it simply isn't. So it's not a debacle, and I do not propose to open a discussion on the merits of modern architecture. I'm not talking about the aesthetics of the court's current premises. We just drove past it. Actually, Antoine was a bit surprised. But of course, I'm not talking about the way it looks. That's of course largely a matter of taste. Some might prefer the stately mansion that was the old Villa Vauban, in which the court started out in the early 1950s, but that's a wholly different story, perhaps something also for a different conference. And some of you here, of course, will spot the reference. There's, of course, this sentence drawn from René Magritte's Les Trahisons des Images. And we all know there's a very insidious quality to that particular phrase, and that insidious quality is intentionally left in place. So, but in any case, make no mistake, there's a serious undertone here. As many, and maybe all here will acknowledge, any serious scholar has to own up to the fact that the development of the Court of Justice of the EU is by and large a success story. There is no other comparable regional court with a general jurisdiction that has been around for an equal number of years and thriving at that. And beyond that, it's not only the fact that the court has survived during the decades, but also the fact that it's functioning well and that the court is commanding a sizable respect, and that may be considered wholly remarkable, possibly unique. However, as also discussed yesterday, survival as such is not sufficient proof of a non-debacle. So you could say perhaps no debacle has taken place in the traditional sense of the term, but as I already underlined in my paper, we do indeed need to adopt a wider understanding of that notion. And then indeed, we can readily admit that every success story has its darker sides, and that also, under that wider understanding of a debacle, there's at least a collection of shortcomings that may be brought to the fore. All that glitters is not made of gold. Lest we forget, of course, something made of silver might still be pretty shiny as well. But then silver, of course, still being second prize, second to gold. So it might still be valuable, but and glitzy, but still some remarks to be made, some defects which deserve to be pointed out. So then there's a collection of shortcomings, which I've chosen to highlight in my paper, and there are 4 in number, a quartet which I would not be inclined to expand any further, but at least a quartet of defects, which to my mind have not been receiving the academic attention they are fully due. And if only for that reason you could say they seem rather covert, at least to my mind, it's the first time that these singular disparate elements have been brought together under a common heading. So this conference actually offers the opportunity for bringing those defects together under a common heading, which I think also so far is something which we have failed actually to see in legal doctrine so far. And these are, first of all, what in my paper I've decided to label as confined authority. And that's a feature that flows from the, you could say, relentless tug of war between the court in Luxembourg and its interlocutors at the national level over the past decades. And with interlocutors, of course, most prominently, that refers here to national courts. So basically here we have a bit of, a situation, you could say. Not all national courts, I hasten to add, but still some of the rank and file that, if possible, one would prefer not to pick a battle with. And then I obviously refer to the German Bundesverfassungsgericht, and the dynamics will be familiar to most observers. We've had a typical tale of the dog in Karlsruhe, which kept barking, but hardly ever bite. Of course, we have actually seen elsewhere a barking dog bite in the form of the Czech Constitutional Court, the Lintova and Holubek jurisprudence, actually repudiating the supremacy of EU law for particular reasons, it should be added, but at the same time you could say, well, the risks of the past have become at least more than just imaginary, and more may still follow. There's plenty to be said about this, and even more that's already has been published, but where I've attempted to place the finger in my paper is, we could wonder where does the blame lie, actually, for the kind of here, the relations which have been established, which are fractious in different ways. Where does the blame lie? Or to paraphrase John Cleese in his eternal magnificent role as Basil Fawlty in Fawlty Towers, the Germans episode, who started the bloody war anyway? So here you can wonder indeed, well, perhaps there's something to be said for a more gentle approach from the European Court of Justice, instead of actually upsetting its various national counterparts. And there we can rewind almost to the beginning through judgments as Van Gendeloos, Costa Enel, and also the dairy products case, to which Will Phelan has rightly drawn attention to. With those courts, with those cases, you could say a bit of an upset in itself was caused. I think basically there's no denying that that sparked off the whole further dynamic. And perhaps indeed a rather more moderate approach could have prevented, or would have prevented, the still ongoing and still unresolved tussle. And if indeed that tussle, or the trench warfare, you could say, if that could have been avoided, then a very interesting side effect, actually, that would have meant that the need to come up with the legal pluralist paradigm, at least in Europe, that would not have been necessary. And that perhaps would have saved us quite some trouble, at least quite some argument. And, well, with legal pluralism anyway, we also know it doesn't reconcile the underlying conflict in normative terms anyway. So, in that sense, also, how useful was that addition to the debate in itself? So, the point I'm trying to press, after more than 60 years, well, we have this battle for supremacy, or trench warfare, and the ramifications are clear enough. And those ramifications, actually, of that tension stretch out to the political and the economic realm. If you take just, for example, the fact that whenever you have a new judgment imminent from either the Kirchberg or from Karlsruhe with regard to, well, outright monetary transactions or other aspects also of the economic and monetary crisis, we saw politicians and also actually stock markets holding their breath whenever a new judgment was imminent. And, well, there we still have that process, which apparently after 60 years here, this authority is still left unsettled of the European Court. And this kind of, fractious relation could ultimately still usher in a great conflagration. And perhaps by a more measured strategy, maybe that could all and should all have been averted in the first place. So, on any count, I would say, we do encounter here a failure in the sense of what Luca Pasquet flagged yesterday, a speaker being unable to sway his audience totally and permanently. So, at least in that sense here, I could say, also with the Chaim Perelman approach to indeed the function of rhetorics, here at least a rhetorical failure from the side of the European Court. Then next there's still something rotten, you could say, with regards to the judicial selection and appointment process. And then it should immediately be conceded, much has been improved with the entry into force of the Lisbon Treaty. As many court watchers were willing to agree also at the conference at the Collège d'Europe only a few years ago. Some of you may have spotted the resulting volume edited by Michael Bobek. But here again, all that glitters is not golden. There are some matters which already seem skewed at the dawn of European integration and which have nevertheless been left unaddressed for over 50 years now. So we have now basically an extra safety valve. Some improvements have been made, but there are some matters left unaddressed which continue to leave the court vulnerable. That much is certain. The matter is further explored in my paper, and time is too short to do the issue justice. Indeed it is. In short, I may point first to the blind acceptance among member states of the risk that persons lacking the proper qualifications are appointed. So since 2010, we do have the extra safety valve in the form of a selection panel, and that used not to be present before, and in the past, actually, without any debate ever, you just had the nominees being rubber stamped in itself, and, well, whoever got in, and basically that was that. And, well, there are actually some stories from insiders which also testify to the fact that in that way, at least here, an optimal quality was never entirely ensured. to put it mildly. Now, we do now have a selection panel, but then, interestingly, or perhaps somewhat embarrassingly, in the first few years now, it has so far rejected almost 1 in 5 proposed candidates. And, well, if that's also the story of the past 5 years, then that makes you wonder about the quality of those appointed in the 50 years before. So that's one thing with regard to the modern state of play, also linking in with the past here, the history of this particular institution. There's also still the continuing lack of transparency in the appointment process. And, well, there's a lot which could be said about that as well. Alberto Alemano, to my mind, is pushing the case a bit too far, but at the same time, also in my paper, I further do engage with that particular critique, and I think also a greater measure of transparency is still feasible. That's the second element here. A third element would be, you have the term of office, still the classic renewable 6 years, which poses risks for judicial independence, or at least the appearance of judicial independence. And over time, there have been many scholarly suggestions for reform. There have been some political attempts at reform, and again, those failed. So, so far, neither the court nor the Herren der Verträge have so far been inclined to adjust the legal architecture in a meaningful way on any of these counts. So nothing came of those suggestions and attempts, which may count as a failure in its own right, actually. The third main defect, on a similar note, although much has changed through the years, my paper stresses that still today the quality of the case law still leaves much to be desired. It's actually wholly remarkable that a considerable measure of authority could be acquired by the court nevertheless, which indicates that there were apparently other factors at play than just the pure persuasiveness of the solutions that the court came up with. But well, that's another issue further investigated by political scientists, how the authority could be established nevertheless. And many of us here will be aware of the pioneering work of Karen Alter and progeny. But in my paper, I place the focus here squarely on matters of reasoning, the solidity of the arguments employed, and the overall presentation of the judgment. And, well, some actually who take note of the court's modern pronouncements on a regular basis, they might think, well, the statement that there remains cause for concern here, that might sound dubious, so further proof here is needed. And for that, actually, I invite you to take just a very brief peek at the following dictum in a case only decided earlier this month, which means with this advice, I have to skip through the next point. I'll get back to it, but we move on to this slide. We here have a very interesting, well, outcome in itself. Mind, this is a judgment of the Grand Chamber, so it's normally expected to carry an extra layer of authority. And then granted, of course, it's known that with the Grand Chamber, the more judges are involved, the more difficult it becomes to arrive at a polished result. And I also admit, well, it may be easier to grasp this one if you have a greater familiarity with the actual context. But still, I run it past a number of connoisseurs of the subject matter at actually the law schools, both in Nijmegen and in Antwerp, and they still struggle with this one. And then I just can't help thinking that the court could still do better, and that we have not really progressed all that much since the days of obscurity in Van Gent and Loos and following. And here, actually, with Lissou-Granarske, we're basically back at the typical 1950s, 1960s, the oracular single-sentence magisterial dictum. And that simply won't do in the age of good governance benchmarks. And it's for that reason that also in a recent book chapter, Steve Wetherill criticized various strings of cases, recent cases, accusing the court of favoring circumloquacious statements of the result rather than supplying proper reasons for arriving at it. And I think in a way Steve Wetherill seems to share probably Ingo's critique. We heard yesterday Ingo's critique of adjudication. We heard for at least the continuing claim or the continuing pretense of impeccable conduct. That simply isn't true. Then lastly, there are the various tensions and agitations from within. The proud institution which we nowadays refer to as Court of Justice of the EU, it suffers internally from something akin to a multiple personality complex. There's a distinct rivalry between the Court of Justice in the sense of the superior branch, with its sibling, the inferior branch. I hope you'll forgive me, some of the judges here. Now it is called the General Court. Admittedly, again, rivalry is perhaps too strong a term, but there is most definitely an incompatibilité de mœurs, and one which has produced some palpable confrontations in recent years. To an extent, this tension was present from the very beginning, in the late 1980s, and the general root of the problem would appear to lie in the fact that at least some of the judges in the Court of Justice tend to look down upon those in the General Court. And while that does not lead to outright clashes and to permanent damage in the legal realm, not something which truly affects the coherence of the case law, you could say the relation is definitely still an uncomfortable one in itself. I'm drawing to a conclusion. There are signs, thankfully, that a new wind has started to blow here, with a new president of the institution, Koen Leenaerts, which previously served at the Court of First Instance, and that's a first for the institution to have someone with that particular background. So the first president ever who served before at the General Court. And on that cue, perhaps the pressures will be quickly further removed from the boiling point which they recently reached under President Skouras. But only time will tell. And then only time will tell as well if these are all just some cracks in the edifice which could still easily be mended, or cracks which will stay in our sight for at least a little while longer. Well, a little while longer. I will not take any longer myself. Many thanks for your patience. I look forward to further questions and discussion.
Thank you very much, Henri. Now, we know that la Cour peut mieux faire. But at the same time, what is probably one of the most striking accomplishment of the European Court of Justice is actually the linearity of its historical trajectory, its capacity, in a way, from the early 1950s to, in a way, go through a variety of political changes and the incredible change in the, the scope and the institutional setup of the European Union, and still, in a way, be a sort of a point fixe in EU polity. So I think, in a way, this is interesting compared to what we'll now listen with Freya Betens, who is an associate professor of law at the Europa Institute in Leiden, and among the many responsibilities, you're also, I think, a co-editor of the Leiden Journal of International Law, and indeed, what you're going to talk about is a sort of, I don't know if you say that in English, une cour intermittente, an intermittent court, the Central American Court of Justice, which has had various avatars along history, and you will draw, I think, a sort of non-linear history of adjudication in the Central American regional system. So the floor is yours. Thank you.
Thank you very much, and good morning, everyone. I would like, of course, to thank the organizers, not just for inviting me, but for also making a conference brochure with one of my favorite artists' etchings, Piranesi etchings. I hope you actually noticed that. The embellished ruins of Rome, I think that's a wonderful idea. And indeed, Europe regards itself as the birthplace of all things bright and beautiful, from art and architecture over democracy to Roquefort cheese. But one area where this claim is indeed, one of many areas where this claim is indeed not quite correct, is the area of regional integration and of having the idea of a regional court that solves disputes between states, because Central America was more than half a century ahead. So what I would like to do, once I figure out how this works, is to give you a very brief overview of the failed attempts at regional integration and the different adjudicative bodies in Central America. Then to tell you very briefly also what the Organization of Central American States, or the ODECA, and the Central American Integration System, or CICA, is about. Within these bodies is the currently functioning, or maybe not so functioning Central American Court of Justice, and then I would like to draw some lessons for the future, both for this court and for another court that is currently being discussed. Now, firstly, Latin America started really early, already in the first half of the 19th century, with trying to regionally integrate a number of countries. So we first had the Federal Republic of Central America in 1829. That lasted for about 20 years. The Confederation of Central America was actually in 1842 till 1844. The Federation of Central America was for about 1 month in 1852. Then the Greater Republic, or even the United States of Central America, only 2 years as well. And then the Federation of Central America, well, that made it for about 1 year. The recurring problem was that the political, institutional, and social waters between the countries were simply too deep. However, even in this very early period, there was the Corte de Justicia Centroamericana. I really apologize to the Spanish speakers for my pronunciation. That was founded in 1907, that operated for about 10 years. The idea was actually very much pushed by the US, that there should be a Central American Court of Justice, a permanent judicial institution that was based in Cartago in Costa Rica. And the idea was that it would counter the constant armed interventions and counter-interventions between Guatemala, Honduras, Nicaragua, and El Salvador. And so this was actually what I would dare to call the first regional court that could issue binding decisions on states. And also very ahead of its time, this court could not only accept claims from states, but also claims from individuals. And it had exactly 10 cases on its dockets with mixed results. Half of these cases were brought by individuals, and they related to denial of rights, false imprisonment, illegal arrest, expulsion, and all of these people lost. So in these 5 cases, for various reasons, not admissibility or facts not proven, these individuals lost. The other 5 cases were brought by states, 2 related to an internal conflict in Nicaragua, 1 related to an alleged invasion of Honduras by Guatemala and El Salvador. But the 2 that created most discussion and that to some extent signaled the end of the debacle of this court were the 2 that related to the application of the Bryan-Chamorro Treaty between the Central American states and agreements that various states had concluded with the US separately. And there the court said, no, our own treaty should prevail over the agreements with America. And yeah, that was that, more or less. Officially, the solution was not so political in the sense that this court had a status that would expire after 10 years, and states simply decided not to renew the mandate. They said, well, there's a problem with judicial independence, which there was because the judges were paid by their state, the state that appointed them. Directly. They said the court has too broad a jurisdiction. It had poorly written rules of procedures. The judges mostly invented the rules as they went along. And it was viewed as politically driven by various parties and over-influenced by the US. It just didn't work. They tried it again in 1923, again under the impetus of the United States. This time, the International Central American Tribunal was a kind of PCA-style arbitration institution that actually found that when the first dispute which was a territorial dispute between Guatemala and Honduras, it never even really got submitted to the court or the tribunal. After the Second World War, they tried again. You have to give Central America this, that they definitely keep on trying. In 1951, there was the Charter of the Organization of Central American States that was signed, which was modified about 10 years later to also include the Central American Court of Justice, which I will be abbreviating as CCJ. But it didn't do anything for 3 decades. In 1991, there was a protocol signed, the Protocol of Tegucigalpa, and that tried to inject new life into the ODICA. A lot of abbreviations, I'm sorry. And it, among other things, established the Central American Integration System, or CICA. And the idea was also to reconfigure the CCJ to take stock of the lessons from the previous court, the one between 1907 and 1918. And it started functioning, and it functions to this day. And then the question, of course, is this a debacle or not? Well, looking at the CCJ, it has still very broad jurisdiction. It can resolve a variety of claims, claims between states, claims challenging the legitimacy or compliance of states with CICA rules, even disputes between government organs of the same country, actions of individuals affected by the CICA agreements or state agreements. They can also, it's not just contentious jurisdiction, they can also issue advisory opinions, for example, when requested by a domestic court. The court, in principle, does not have jurisdiction over human rights issues because that is the realm of the Inter-American Court of Human Rights, but they found a way around that by saying, well, as soon as there's a complaint about community law, that would negatively affect an individual, we can assess it nevertheless. The system of 2 judges per country remains, but you should be aware that, of course, this is not all Central American countries that have signed up. It's only El Salvador, Honduras, Nicaragua, and Guatemala. And that is important because there are more Central American countries than that. There's Costa Rica, there's Panama, there's the Dominican Republic, there's Belize. I actually had to check this because I'm a bit geographically challenged. But so that means there's a lot of CICA members that did not sign up to the court, and that is one of the problems, that it has relatively little support. One of the reasons is that it's seen as, again, the jurisdiction, the competence is seen as too extensive, and that the court, the jurisdiction is already extensive, and the people who are on the court are prone to judicial overreach. And one of the most controversial issues is that it can indeed hear disputes between constitutional organs of the same state. So who can actually bring cases? Well, virtually everyone except cats and dogs, as in states can bring cases, CICA states, states that are not members of CICA but that do accept the jurisdiction of the court for the particular case, organs of CICA, supreme courts, lower courts, natural persons, legal persons. You know, it's very extensive. And if you look at the topics they have dealt with, it's equally extensive. It can be anything relating to property, and there's quite a bit of issues regarding property in Central America, not just tangible property, also intellectual property, for example. Again, all these denial of justice claims, so illegal arrest, imprisonment, etc. Also state non-compliance with any rule that was issued by CICA, so customs rules, for example. So it's quite extensive, and there's 2 powers that created a big fuss, to say the least, and that arguably, or that you could make the case that these have been debacles. The first one is Article 22F of the statute allows the court, as I said, to allow the court to hear cases between judicial or between constitutional organs of the same state, and that happened with regard to Nicaragua, where the president had a problem with the parliament, so this case was brought to the court. What did the court do? It fully agreed with the president. The same case was brought before the Supreme Court of Nicaragua, and of course what happened? The Supreme Court of Nicaragua sided with the legislature. This is actually exacerbating a dispute within one state rather than solving it, and particularly the Nicaraguan Supreme Court then went on the offensive, saying, well, actually this whole statute of the CCJ is against the Constitution of Nicaragua, so we shouldn't be a party in the first place. The second case that... am I still on the right slide? Oh, no, sorry. You should have been looking at this one. Yes. The second case that created a lot of trouble was a case brought by 2 environmental NGOs from Nicaragua against Costa Rica. Now, for those of you who follow the ICJ, this disputes or docket, you might be aware that there's a lot of problems between Nicaragua and Costa Rica, and then having NGOs jumping into the fray and bringing cases again did not really help, particularly because, as you may remember, Costa Rica is not one of the countries that actually signed up to the CCJ. Never mind, says the court, you signed up to the SICA, to the organization. This means ipso facto you're subject to the court as well. Costa Rica was not overly happy with that decision. And other states, frankly, were not either. Does this mean it's a complete debacle? I would say no. The court has heard 173 cases, about 113 contentious and 60 advisory. Since 1994, this is not nothing. Many of these decisions were well received. It has also aligned itself with the case law of the CJEU, and as well as the Andean Court of Justice, which were, again, decisions that were also outside of Central America quite well received. These decisions dealt with the independence of the community legal order, the supremacy of community law over national law, and the direct applicability of community law. So that it has good elements. It's not just it's not a full debacle. It's a partial one. What is the proposed reform? Well, in 1997 already, so 3 years after the court started functioning, the Summit of the Presidents of Central America issued a proposal for reform where they say, well, this Article 22F allowing two organs of the same state to litigate against each other should be abolished. Number of judges should be reduced. There should be an expansion of the competence in commercial matters, different procedure for electing judges, a bit of recurring things in all courts. And then in a truly unprecedented move, the CCJ issued a public statement saying, that's just a load of crap. We don't want this, we don't accept this. Which, was maybe not from a PR point the best thing to do. Nevertheless, at that point, the Supreme Courts of 5 Central American states decided, okay, we go public as well, and they issued a statement against their own president in favor of the CCJ. So the reform never happened. But in the meantime, there have been discussions for an inter-American, so not just Central American, but inter-American Court of Justice. So these 35 member states of the OIAS include the Central American states. Currently, it lacks a judicial organ, and there was, in 2007, a proposal to create a Court of Justice for this institution. The idea was also, for example, you might know the Pact of Bogotá, so Colombia withdrew from the Pact of Bogotá, meaning that disputes cannot be brought before the ICJ anymore. Chile has similar stirrings, discussions in parliament, so the idea was, well, maybe this could be a regional replacement of the ICJ. This proposal has now stalled, and I would like to finish with a couple of ideas. Oops, no. Yes, a couple of rather, I worked them out more in the paper, but rather general ideas of how can we avoid further debacles? What went wrong and how can we prevent that it happens again? Well, first of all, I think whether we like it as lawyers or not, states' trust is vital for the legitimacy and authority of regional courts. If courts go it alone, it just won't work. It will not be, states will withdraw or decisions will not be implemented, and it will sort of adjudicate itself into irrelevance. And what we see is that overly ambitious founding legal instruments can really cripple a court before it has had this chance to build up states' trust. So one idea would be to limit the jurisdiction of the courts and then gradually have a regular review and then gradually expand it. For example, a good area where I think this court could do useful work is commercial matters. As I already said, a proposal in 1997 wanted to add this to the jurisdiction of the court. If we combine this with the withdrawal from ICSID of several Central American states, maybe that would be an idea that investment disputes could be brought here, and that would really be carried more broadly by states. I do understand courts need to or want to take hard cases to prove their relevance, but if you compare to the European Court of Human Rights or the CJEU or the Inter-American Court of Human Rights, this at least a decade, possibly even more, before they really started to have a big impact. So I would like to leave you with one final question, and that is, are we not overemphasizing the role, functioning, and ability of courts to actually solve interstate disputes? It's a bit a chicken or an egg question, but can courts really bring about peace and stability in a region? Or should there first be peace and stability as a necessary prerequisite for a court, any court, to successfully function and not be a debacle? Thank you very much.
Thank you very much, Freya, for presenting all the turbulences, the difficult history of Central American international forms of adjudication. And also with you, and thanks to your presentation, I think we're starting to engage, again, as we were doing yesterday, to thinking about the reasons for success or failure, or the various yardsticks through which we can actually measure that. In a way, being a political scientist, I think there is also a variety of disciplinary paradigms to measure failure and success. I think, in a way, in law, there's one of the yardstick is the justiciability of the text of the convention. I think in political science, there's an emphasis on compliance, implementation, public, vis-a-vis policymakers. I think in history, there's an insistence, and we talked about it yesterday, on survival, on resilience, on path dependency. And I think in sociology, there's, I'm turning to you now, Andre, in a way, or sociology of law, there is an insistence on legal consciousness, legal awareness, the capacity for which particular legal communities in particular actually use and think of specific international instrument as usable in various contexts. And in a way, I think, Andre, you're putting yourself in this tradition in part, and you're a PhD candidate at the Université Paris Sorbonne and a research fellow here at the Max Planck Institute. And I think one of the arguments you're making here is that if we try to think about failures or difficulties, trials and errors in the Central American courts of justice, then we have to look at maybe specific issues within the constitutionalist community in Latin America, and maybe specific structure of the Latin American legal field. So the floor is yours. Thank you.
Thank you very much, Professor Boucher. I'd like to also extend my gratitude to Professor Ruiz Fabri and to Lorenzo Garadoni for organizing this very interesting conference on an outstanding topic. And straight to the object of my presentation. As Professor Boucher has mentioned, the Corte de Justicia Centroamericana is also one of the objects of my paper. But for the purposes of this presentation here, I will be trying to focus only on the history that culminates in the Inter-American Court of Human Rights. And basically, my argument is that there is a lot of the history in the understanding of the structures of regional courts in Latin America that we miss out by looking only at international law in Latin America. So recent history of international law in Latin America focuses mostly on the professionalization of the field at the end of the 19th century, especially with Carlos Calvo. And what I'm proposing here is to take a step back and to look instead at the masterminds of the constitutionalist thought in Latin America in the beginning of the 19th century, and to see whether from there already there are enough arguments in a legal imaginary for the continent already is being built. When you look at the works, for example, of the kinds of Juan Alberdi or José María Samper in Colombia, and Domingo Fausto Sarmiento in Argentina, one can already draw out that there is already not only a constitutionalist mindset being drawn out there, but also a thought of unity of the South American continent. Well, what I'm trying to do here is not properly a doctrinal work. So what I'm trying to do is look at an intellectual history of Latin America, of the Latin American legal field, but at the same time, I can't. This alone wouldn't allow me to make the claims that I want to make, because it would just lead me back to this liberal international law thinking that finishes up in the 19th century, that originates in Latin America, particularly at the end of the 19th century. So what I also tried to do was to look into the various Pan-American conferences that took place already in the beginning of the 19th century and end up in the early 20th century, and to see whether within also state practice, there isn't anything there that tells me about this, what I'm calling the legal imaginary in Latin America. For this particular purpose, I mean, just a little note on the sources then that I used was basically going and I drew a lot on the works of these constitutionalists, Latin Americans, and in particular of the Argentinians, Colombians, and Chileans who first thought the idea of unity of the South American continent. And I looked at the proceedings and various letters being circulated in these Pan-American conferences. So one of the features of my argument is that there's a constitutionalist mindset that is developed within the South American continent by means of the influence of these authors, who were not only scholars, but also took part in the politics, in the organization of the states in these countries, in Argentina, in Colombia, and we're also thinking about the unity of the continent in terms of public law. This is very much illustrated by the fact that already in 1821, in a letter circulated by Simón Bolívar to instructing its delegates, the Peruvian delegates to the conference that will take part in 1823, he says that after the ratification of the hopefully treaty that will come out of the Pan-American Conference, that this will be constituting the first public law, that people in the future will look back and say this is the Latin American public law. So there's already a public law and a constitutionalist mindset being drawn up there. Well, the treaty that came out of this conference failed to be ratified by all the countries, including Mexico and also the invitees of Argentina. But this nevertheless instilled a very strong intellectual framework that allowed that actually provided for these politicians to always think in terms of, constitutional matters or public law matters when trying to think about the unity of the continent at that time. And I talk about unity just to avoid eventual anachronism, because integration is something that will come out only in the 20th century. At that time, the idea is properly of a unity. So ideas about a federation and separation of powers and things of the sort, they're all at that moment being also thought of for the continent. Well, interestingly enough, in order to actually, at the turn of the 20th to the 19th to the 20th century, there's a clash of mentalities or a clash of mindsets that happens here. Because at that point, having failed to actually put forward proper mechanisms to consolidate this constitutionalist mindset, the United States at that time already was the economic prominent power in the Americas, takes on the role of actually attempting to provide for a sort of an integrated system in the in the whole of the Americas. So in 1821 already, in 1881 there's already a plan to have its first true Pan-American conference, and very much based in the international law liberal mindset, that is liberal in the sense that all parties, all states being equal, and them being the ones actually creating law for themselves, there's no need for a constitutional framework or a mindset or anything of the sort that would actually guide the work in the actions of these states. Basically, my argument is that this clash creates a problem. There's a lack of articulation between this constitutional mindset and this liberal mindset that will actually give rise to a number of problems in the future for these jurisdictional projects that attempt to aid in integration processes, in the various integration processes that will eventually take place in Latin America. Focusing particularly on this, on the case of the Pan-American conferences that will eventually culminate in the Inter-American Court, for example, my argument is that many of those questions that, for example, are explained in terms of monism, choices between monism or dualism, for example, when the Supreme Court of Brazil decides not to follow a decision of the Barreiros Altos of the Inter-American Court and says, I'm not going to review my amnesty law, but at the same time when Colombia and Argentina decide to give direct effect to the decisions of this court, are just not necessarily and not only questions of an international law theory, but also refer and date back to this this lack of articulation between this constitutionalist and this internationalist mindset. A number of examples can also be drawn and can also be given in that respect. I mean, Professor Barton spoke about the Central American Court. This clash can, for example, in this case, briefly be illustrated by the fact that the Central American Court of Justice of 1907 had been drawn up to be a sort of had been inspired by the previous Supreme Court of Justice that had been in place during the Federal Republic of the Central Americas. But because of this instilled liberal intellectual framework and the influence of the United States, for example, allowed for example, Costa Rica to make a fundamental reservation to the annexed article that prevented it from actually, prevented this court from actually solving cases of conflict of powers within these countries. In the history, fundamentally here, when we look at the history of the Pan-Americanism here, one, and goes back to the constitutionalist, the Latin American constitutionalism being developed in the 19th century. One of the fundamental aspects that I draw here is a conceptual framework being devised by Roberto Gargarella, an Argentinian constitutional lawyer, who identifying the, when looking and identifying a Latin American constitutionalism, separates this constitutionalism in two parts. One is that of the Charter of Rights, and the other one is what he calls the engine room of the Constitution. And the engine room of the Constitution is basically the way in which the Constitution organizes its powers. And the organization of powers, in this sense, also reflects the understanding that the Constitution, or those actually under the Constitution, have of the different powers within the system. And when this lack of articulation between this constitutionalist mindset and the internationalist mindset happens at the turn of the 20th century, there's a problem in the way that actually Latin American countries will start seeing the function and the role that an international judiciary should play in this regional integration process. And interestingly enough, this is one of the reasons I argue for which, for example, the Central American Court of Justice fails to achieve and to actually be continued after its 10 years, its first 10 years mandate. When we look at the way in which the Inter-American Court has been set up, it had already been devised throughout the whole of the history of the Pan-American movement, a scheme where rights had already been ascribed and identified as being a fundamental element constituting the unity of the whole of the Americans, but the organization of powers was still to be, to a large extent, to be organized, to be devised. And when we look at the convention, the American Convention of Human Rights, we see that the OAS already previously with the Inter-American Commission had already set out a plan to basically allow for a balance of powers in that sense. When we look at the way in which, for example, they relate, and the way it should be actually, the way in which these structures should actually relate to the states. So to a large extent, the engine room of this constitutionalist project, to a certain extent, is being to a greater extent being a lot more elaborated than it had been compared to other projects. Now, the question is, what is it that happened? Why is it that this articulation failed? And one of my hypotheses here, one of the findings that I had, is that there was a great deal of problem defining what was actually this Pan-American law in the beginning of the 20th century. And this Pan-American law was at the same time a mixture of constitutional law, but also had a great deal of liberal international law involved. And in this respect, this is very illustrative of this lack of proper understanding of how powers should actually be devised at a regional level, especially considering that ideologically they were very much into guaranteeing that there would be a set of rights that within a public law framework would allow for the protection not only of states but of the peoples of these states, but at the same time they wanted to guarantee that sovereignty would be respected. Because to a large extent, these Latin American states were very much interested in also guaranteeing, it was very much in their interest that this liberal internationalism actually guaranteed them to act in such a way as to just preserve their authority at the international level. But this lack of articulation actually prevented ultimately the way a common agreement on the role of this international judiciary at the regional level. This ultimately leads to the fact that it is very hard for one to it provides a different explanatory framework for why eventually these courts at the regional level have not attended to their integrative powers to a large extent. So basically, by not engaging in dealing with the organization of powers at the regional level, they have failed so far to actually attribute a proper meaning, differently from what happened, for example, in Europe, to the role that a judiciary, even though it's even if just a human rights court or the Central American Court of Justice, they fail to attribute a proper meaning to this judiciary and to actually divide competences and attribute proper functions and relate not only to the other organizations of the continent, but also vis-a-vis the states. Now, I think with that, I will stop here.
Okay.
Yeah. Thank you.
Thank you very much, André, and thank you to all of you to have kept within the constraints of the time limit. I think one of the very important point that you make is to embed a little bit this Latin American experience of international adjudication in a way in another genealogy, not just a genealogy of international law, or a genealogy of where the European experience stands, in a sort of at the top, and all Latin American experiences actually derive from there. In a way, what I find very important is the term of unity, the unity project instead of the integration project, because then it means that one of the models for building, I mean, I'm speaking, of course, sous votre contrôle, but one of the models then in building these courts is not only international courts, but also, as you mentioned at some point, supreme courts.
Yeah.
Because in a way, if you're trying to build a political system that is united at the continent level or subcontinental level, then the model is not the European courts or international courts, but actual supreme courts. So in a way, you also connect this archive of international adjudication to, the larger set of experiments and set of experiences that is the one of, national courts in general. So I think from there we can have some half an hour. We can, I think, take a little bit more time outside of the schedule since we started later. And I think we'll proceed like we did yesterday, taking some 4 or 5 questions around and then make a round of answers. So yes, please, behind you. Yeah.
Hi, my name is Aravind Ganesh, and I'm a research fellow here at the Max Planck Institute. I've got a very workman-like question for Professor Devala about, I completely share your concerns about the impenetrability or the amazing pall of silence that appears to cover everything the European Court does, which goes to more than just an oracular and sometimes infuriatingly dense style of writing. It's like I was trying to figure out the proceedings earlier in a certain case, and I knew a lawyer who was working on it, so I asked if I could see the commission's pleadings, and I was told that I can't do that because they're privileged documents. Now, where I usually practiced, court pleadings were actually public documents which everyone was supposed to be able to access. So I was wondering, do you know of any ways or means of figuring out what individual judges or what the majority of the court, of the people on the bench think? The only thing I can think of is looking at the Advocate General's opinions on the basis that each opinion is a sort of campaign to convince a majority. Do you have any other tips or ideas to figure out what's going on in each judge's head?
Breakfast jurisprudence. Yes.
Thank you very much for the presentations. I have a general question for the panel. In your view, is there a direct link between the degree of cohesion of the regional integration systems on the one hand and the strength and success of the respective courts? Can you imagine, based on the historical examples, having a relatively weak regional integration system with a strong court, with a successful court, and vice versa? So is there a direct nexus?
My question would also regard the first paper about the European Court of Justice. You talked about this animosity between the judges of the court and the Court of Justice, or the General Court and the court. Does this perhaps has to do with the different backgrounds of people? Do the judges at the Court of Justice see themselves more as political actors to some extent, or versus more judicial socializing in domestic court systems of the many judges of the Court of First Instance?
Maybe one or two more. Yes, in the back.
My name is Loïc Cobanel-Lerin. I'm research fellow here and PhD student at University of Paris 13. My question is for André Nunes-Shaib. You talked about failure of Latin American court, and you said that there was a lack of articulation between international law and national law. Today, I cannot imagine this lack of articulation in the Inter-American Court of Human Rights. There is the process of exhaustion of local remedies. There is the prima facie assess of the case, which allows to pull back all problem with national court or the interpretation of national law or the confusion between the Inter-American Court acting as a court of appeal of national court. Can you go very deeply on the problem of this articulation, please? Thank you.
If there are no more questions, maybe we can start in the order of the presentations. And I guess, in a way, the first questions on how can we assess, in a way, and investigate judges' opinion may extend to all of you beyond the European case. So, please.
Okay. Yeah, thanks very much for these questions. A very workman-like question. I'm not sure how to deal with those. I prefer not to get my hands too dirty myself. It's a bit of a consulting kind of question, almost indeed working, of course, through research on cases and trying to find out indeed what's in the mind of the judges, what kind of dynamics indeed play out within also the different chamber formations. Maybe first, to make a general point in reply, I wouldn't criticize, let's say, an overall lack of transparency. I think there are certain elements, particularly in the appointment process, where you could still say that an additional measure would still be welcome. And there also, yesterday I did pick up that also with the new president of the court, actually there might be a whole new wave here of openness about to arrive. and actually also a recent campaign to make the EU courts tweet, to use Twitter for whatever use that would serve. But to my astonishment, actually, that campaign proved successful rather quickly. So apparently here, indeed, there is something moving. Well, on different count, also quite recently, as perhaps Antoine can testify, to access the archives, to also get the full-blown, your hands on the papers from the past. There also still, there was some resistance left, hampering decent historical work. But specifically your question, so what individual judges think, and indeed, well, possible points of entry to get to become more in the know. Well, I think to really practical, maybe workman-like approaches. Of course, if you would become a referent there, that's one way to get on the inside. Or alternatively, become a psychologist at the Kirchberg, and maybe you would be consulting some judges who have been outvoted all the time, and they suffer heavily. So as they shrink, you could perhaps also get in the know. But, well, rather more seriously, of course, it is a typical problem indeed that, like you say, with Advocates General, we can also try to pinpoint what possible correlation there would be between appointment and reappointment. And there, often people mitigate the risk to judicial independence that actually judges themselves will not be so dependent on their governments because we don't know how they vote anyway. So they will not be held to account. And in that way, actually, these renewable 6-year terms can actually be justified. So there actually, I would wonder, is that also the kind of openness which you would like to see? There's a rather eternal argument in legal literature for dissenting opinions. And so far that rally lasting for also maybe already the entire lifespan of the court. Apparently there in Luxembourg they simply won't budge. And I won't see that changing with the new president either. And that does remain remarkable. If we say Supreme Courts can be the yardstick in a way, well, we see that also happening at many Supreme Courts anyway. We see it happening in Strasbourg. We see it happen at the US Supreme Court. So actually, Luxembourg might be in a minority here. But, well, until that change is made, I'm afraid, yeah, there's indeed no real way here, while remaining on the outside, to be able to peer in and see indeed what moves individuals there. Well, the general question asked, I'm not sure if it applies fully to the EU system, but maybe just briefly, and I'll leave it to my colleagues. The nexus between a relatively weak system and a strong court, I think it's a difficulty here, a question of standards. Actually, what are your benchmarks to say, well, the system is weak and or the court is strong? Yesterday we had a very interesting claim, or I think also Ingo said that the weaker the court is, maybe quoting someone else, but the weaker the court is, the more categorical the statements. And, well, that I could relate to the European experience that you do see, of course, in the 1960s, when there's still a lot to be accomplished. You have some rather striking, bold pronouncements from the court of the EC, and then indeed they do wonder, didn't it prove to be counterproductive in a way? So it has ultimately strengthened the system. But that's again also hindsight bias, what we also talked about. So maybe indeed also certain statements would not have to be made because, well, the authority would have increased otherwise anyway, and the system would have expanded in its own right. But still, depends on what you define as strong and weak. And lastly, Professor Fassbender, yeah, a very interesting question indeed. One I struggle with myself to explain indeed there the difference, ECJ, GC, European Court of Justice, General Court mentality, so to say. You would think they are cut from the same cloth. You have the same kind of system. Also, in the newly revised selection mechanism, they do not really differentiate in terms of background, in terms of expertise, what kind of qualities you should have to be appointed at either court. So you could say, at least from 2010 on, we should expect a similar type of person also to make the grade and to be also approved by the panel to take up office, regardless of where he or she end up. But indeed, looking at the past, whether indeed there perhaps already the member state governments were quite scrupulous to say you are rather more suitable for a job at the General Court, and you would do better indeed at the superior branch for the rather more political issues. Well, of course, in a way, it does make sense because originally, of course, the General Court formerly the Court of First Instance, has this rather more administrative jurisdiction. The type of issues coming before it, well, you could say a number of persons already selected in the past. Indeed, they do have a different mentality and also a different, maybe, quality to cope with rather long, protracted disputes on staff cases, competition law, intellectual property, etc. And if that's not entirely your cup of tea, you might also resist a nomination to the European Court of Justice, to the well, most powerful political branch. And well, lastly, here something I do point out in my paper. I think there might be a psychological dimension here. You could think of the natural tension which exists between courts at different levels everywhere. The job of a judge is basically you're asked to solve a particular issue and to get it right. And at whatever level you're functioning, I think psychologically, indeed, the judge would think that's indeed my task. But then how infuriating, indeed, there's another one tasked with that same job. So if you're working at a certain level, there will quite often be a judge at another level, and his or her task will be to get it right as well. But how is that possible? Because you've done your best to also strike the right balance. And on appeal, someone else can say, well, you did it wrong. That's really infuriating. You could almost take it personally. And of course, I think that kind of sentiment, that psychological mentality, disposition, also probably works the same way at the court here around the corner. But at the same time, maybe a difficulty to actually to cope with that hierarchy. I mean, we all know it's there, but at the same time, everyone would prefer not to be overruled. Maybe that links back with the first question, even.
Yeah, thank you. I mean, I just want to make one point in a way which is what is happening at the same time in terms of transparency. Just went through my mind that what's happening at the same time at the European Central Bank, where actually the board, ever since January 2015, has decided, against a lot of resistances actually, that the discussions within the board would be anonymized but still made public, and sort of a count of the arguments that have been exchanged after each decisions of. And in a way, I think it's interesting to think of what other EU institutions, independent also, facing similar issues in a way, are actually doing. So this is just one point in this debate. So maybe you want to.
I can be very, very brief. If you want to investigate judges' opinions, I would say change to the CCJ, because if there's such a thing as too much transparency, they've probably achieved it by issuing public statements entitled "In Defense of the Court." They also do TV interviews and newspaper interviews, so you'll get a lot of material if you can read Spanish, that is. With regard to the nexus between the cohesion of the legal integration system and the strength of the courts, I think there's definitely a correlation. That doesn't mean there's a causation, but I would agree with the statement that the weaker the court, the bolder its statements. And I think there's a lot bigger influence on that a strong integration system can exercise over a court than the other way around. I think that the means of a strong court to influence the political integration system are more limited, but not non-existent.
Andre?
Well, just to answer this first question also, relating the success of regional integration projects with the strength of courts, I do agree that to a certain extent the weaker the court, the bolder its statements. I do, however, think that courts have the potential to serve as the compass, as the guiding mechanism for a stronger regional integration. I mean, my impression is that in Europe, the European Court of Justice has, to a certain extent, done that. The problem is that in Latin America, for example, we haven't had actually an agreement, a proper political agreement as to what function should these courts actually have within these regional integration projects. I mean, to a certain extent, the problem there is that there is no proper sense of the function that these courts should have in playing an integrationist, so to say, role. And I think first, before actually defining in which way they actually correlate, one has to decide which role should these courts actually play within this integration projects. Now, turning to Loic's question, thank you very much, because this allows me to actually clarify. I wasn't actually saying that there is a lack of articulation between national laws and international law. The point I was trying to make is that at the turn of the 19th century to the 20th century, we have the constitutionalist mindset from South American countries who have tried to create some sort of unity, as Professor Rocher has just mentioned. I mean, this is very important because this is not properly integration, but basically to allow themselves to unite under a common public law with a classical international law view that does not necessarily rely on a public law framework, but rather rely on analogies on private law. I mean, I don't need to go deep into that. And it's this clash between these two different mindsets that originates this confusing Latin American legal imaginary that ultimately creates problems later for the way in which different countries will relate to these regional courts. And this is the point I was trying to make, that ultimately some countries, I mean, the choice is made in some countries between I will actually take this court as having authority over my Supreme Court, for example, or no, ultimately my Supreme Court has authority over whatever they decide, finds its roots, is my argument, in this lack of articulation between these two mindsets. So it's not only a matter of politics, as many would say. It's just, well, I mean, it's a monist dualist argument, or it's just a political choice not to follow, or Venezuela withdraws from the system because it's simply, the decisions do not, the decision against Venezuela, I think in 2013, did not please the government. Well, these are interesting and maybe explanatory frameworks, but what I'm trying to say is basically that there's something a little bit deeper there. And that I think that this lack of articulation between these two intellectual frameworks is at the very basis of why in Latin America, for example, to come back to the point that you've made, courts have actually failed to acquire a proper integrative function, so to say, because there is simply no agreement as to what they should do in the continent.
Okay, thank you, Andre. Yes, maybe we're going to take another. I'm curious about, or a little bit skeptical, I must say, about this hypothesis that is emerging about the weaker, the bolder. It's actually something that seems to be very counterintuitive to me, and very, in a way, runs counter to what I've been, looking at in the case of both European courts. And I wouldn't say that the European Court of Human Rights was very bold in its weaker days, and wouldn't say either that the European Court of Justice was very bold in the 50s when it was at its weakest point. So I'll be happy to engage in that discussion or continue that. But I find a number of actually counter arguments or counter cases to that connection. But I mean, this is an open discussion. So maybe we take we have another 15 minutes. So some questions. Yes.
Yes. Anthony Collins, Judge of the General Court. First of all, I want to thank the speakers for a fascinating set of presentations. And there's a lot that could be said about everything that's been said this morning. But I have some observations just to make in relation to Professor Duval. They're sort of questions and sort of statements. The first thing I think is important, and in relation to two of the items you picked up as possible problems with the Court of Justice, relating to the Cain and Abel matter, I think it's important to understand that I don't believe that's a problem about being overruled by the Court of Justice. In fact, the General Court's success rate on appeal is extremely high. The current statistics are that 3.5% of decisions made by the General Court are overruled by the Court of Justice. That's quite low by national standards. Furthermore, I think it's fair to say, and I'm speaking personally and off the record, that notwithstanding a very difficult period through which the institution has come at the moment, which is still not concluded, I should say. In relation to that, it's important to bear in mind that the juridical output of the General Court not only, in fact, continued, but in fact increased. If you look at the statistics for the recent past, you'll see an increase in the output of the work of the General Court. And as I say, no diminution in terms of quality, because I'm strongly of the view that the only way you can assess the quality of a court of first instance is the success level of the appeals against its decisions. Every other benchmark of quality, which is often addressed, is completely false. That's different for the Court of Justice because it's a final court. There you can have academic debate. But in the Court of First Instance, if the court is right, then its judgments are upheld, and if the parties don't appeal against the judgments, then they're content with the judgments. That's the job of a Court of First Instance. So I think it's important to bear in mind that the Cain and Abel problem, as I would see it, arises because of fundamental institutional structures. In other words, the Court of First Instance was carved out of the Court of Justice. The General Court, as it now is, has a much greater jurisdiction, and the question one has to ask is the current institutional framework fit for purpose? Ought we not to be looking, in fact, at the establishment of a separate institution, namely the General Court? Because it is a separate juridical institution. In terms of arrangements, practical arrangements, they could be done on a very, very simple basis. As at the moment, we know institutions share translation facilities, recruitment facilities, and so on. That can be done. But I think it's going to be an eternal difficulty, and the lines of tension are not to be seen in the juridical sphere, but more in the administrative and the political sphere. The next observation I just wish to make is concerns, that's a question you raised as well, I think it's very important, is the, and it's a very delicate balance, is the 255 committee. The 255 committee, there's no doubt, has contributed, its existence has contributed to some extent, putting manners on the member states and improving overall the quality of appointments to the General Court. That cannot be denied. But you always have to ask the question, quis custodiet is ipsos custodies? At present, the 255 committee doesn't contain any member of the General Court. And I noticed Professor Debacles' statement that 1 in 5 appointments has been refused. A very, very small number of those, if any, have been appointments suggested to the Court of Justice. So the 255 committee is very clear on reviewing appointments to the General Court, but seems to have very little to say, mysteriously, when it comes to appointments and reappointments to the Court of Justice. And the difficulty with that is that in a system governed by the separation of powers, the executive, which is answerable to the people via Parliament, is supposed to appoint judges. Now, clearly, it is useful to have some form of review or control. You can have the American system. You can have a system such as my own state, whereas is that the appointments made by the executive and effectively is beyond review. Or you can have a situation in which you have review by whom? By judges. Don't forget the 255 committee, the chairman is appointed effectively by the president of the Court of Justice. Now, the current arrangements have worked very well, but one always has to keep one's eye open as to whether they will always necessarily work so well. And one has to inquire, for instance, in the recent round of appointments to the General Court, the government of Malta nominated this Chief Justice. Under the Lisbon Treaty, it's clear that to sit as a judge of the General Court, you are supposed to have what's called the ability to sit in the higher courts of the member states. There's no renvoi to national law, it's a simple question of ability. One wonders how a 255 committee could decide, and we don't know because we can't see the opinions, that the Chief Justice of Malta was unfit. Unless one is talking about some form of stated misbehaviour or stated misdemeanour, it's very difficult to understand. So one must be careful to constantly keep an eye on the operation of these bodies, particularly in circumstances where it's not at all clear that the area in which they're exercising their power, that the committee itself has any necessary expertise in the area in which it's exercising its power. And I wonder if you'd have any comment to make in relation to that particular aspect of matters. I don't believe that that there is a big gap necessarily between the level of appointments, but between the personalities involved in the two courts. But I do believe that it is important to note that the General Court's composition, leaving aside the doubling that's recently taken place, has changed considerably more in the last number of years than the composition of the Court of Justice. And a number of the judges in the Court of Justice were formerly members of the General Court at a time when the General Court was clearly in crisis. Does that transfer through to the so-called the debate about the quality of justice in the Court of Justice? I can make no suggestions in that regard. But again, I wonder if you might have any comments to make. Finally, on the question of transparency. One clear area where transparency could be afforded would be for the Court of Justice to do what the Court of Human Rights has done, which is live streaming of broadcast of the debates. Where is that on the agenda at the moment? I simply pose the question. Thank you for your attention.
Thank you very much indeed. Maybe there are more. Moshe, yes, this is.
I wanted to ask Andre. It seems that the debacle that you are talking about, it relates to some clash between the constitutional mindset of Latin Americans, the idea of unity of the legal system and so on, and on the other hand, some concerns about protecting sovereignty. So with regard to the second element, do you think that these anxieties or sovereignty concerns, they are related to some external interventions by European powers or United States, gunboat diplomacy or things like that, or it's more about internal conflicts among the states of Latin America?
Maybe one last question, if there is. Okay, so this is your turn, André.
Yeah.
Oh, yeah, sorry. Henri,
yeah, reverse
sorry.
order, is possible? Yeah.
No, take your turn, sorry.
Good. Okay, well, thanks, many thanks to Judge Collins. Splendid observations. My thinking process on a number of points is just starting, so I won't finish before I will have stopped talking. But indeed, splendid observations with still think indeed some queries wrapped into them anyway, it seems. I think basically to start with, I think we're on the same page, that indeed it's more of an administrative issue in itself than a purely legal confrontation, and an issue indeed of overruling in itself. So as you also made clear on the basis of the numbers, still I think on that element, you might indeed say it's no problem of being overruled, which can be indeed statistically underpinned. But we all know the famous remark, of course, the damned lies in the statistics. So what I still would find tricky with that particular element is that, well, the case is concerned where the General Court is overruled, what those cases actually are about, that might still matter very much. So even if you could say, well, indeed in the majority, well, ultimately we still, the judgment still survives, well, what's in that minority of cases in which actually you are overruled? You have a similar argument also where in defense of the court, quite often it is said, well, people accuse the court of activism, but actually in 90% of cases, nothing spectacular happens whatsoever. If people critique the reasoning of the court, they say, well, actually in the lion's share, it's actually picture perfect, nothing to complain about. Well, then indeed it seems to be watertight as an argument that indeed people should stop making a fuss. But at the same time, in a minority of cases, you have those landmark rulings which are somewhat dubious, and of course they don't occur every day, but still they do occur, then actually here the quality of those contents actually trumps the quantity. The fact that it's a minority of cases, same deal with the reasoning. If you say, well, okay, occasionally there's still poor reasoning, but it doesn't happen every day, well, I'm not sure that's entirely a saving grace. If you combine the two, if in your spectacular pronouncements you're unable to devise a judgment, to compile a text which carries a sufficiently persuasive reasoning, then you're in trouble anyway. You won't get away with the excuse, it's just only a minority. So here, same deal, I'm not sure, indeed it would call for further research, but they're actually in the minority of cases in which the General Court is overruled. It still might not come easily to some at the General Court who put in hard work, and with regard to the subject matter, are somewhat disappointed that it had to go the other way. And then, well, I think connected to this, basically, indeed, mainly indeed that's more of an administrative matter, and that doesn't really relate so much to the law. But I think there still you do have well, the defect, the shortcoming, which also, as you seem to suggest, is not just limited to the recent friction between the whole Skouris-Jaeger, the much publicized clash with regard to the reform of the court. In the valedictory speech of Franklin de Hoos, there was also so much more. So also in my paper, I mainly engage with that particular aspect, this attempt at reconstructing, also an insider's perspective, internally, what's going on between those courts. And then lastly, indeed, with regard to the 255 committee, so the selection panel, that there's something not quite right there. That's also a very valuable thing to indeed further perhaps also expand upon in my paper. A member of the General Court inclusion, or a past member of General Court, perhaps that would indeed be a nice way forward. I think I would agree. The strange thing is indeed it's possible on the basis of the rules, but indeed that hasn't happened. And well, we've had several incarnations already of the panel, but then apparently here you have the same kind of overlooking the fact that also here there is a real possibility. I think the setup right now of the panel is deficient anyway, because it doesn't sufficiently meet democratic demands you might entertain. The European Parliament had much wilder requests in the past. They also said, well, similar to in the US, we should have full-blown involvement and hearings of prospective judges before the European Parliament. And, well, that was perhaps also a bit of a venture which was sure never to materialize. But I think they're still, with the current panel, with just one member being proposed by the European Parliament, that's also falling somewhat short of the mark. And lastly here, I think also, a thing you didn't raise is with regard to the fit for the future point. Is the panel actually of the right size right now, with the imminent avalanche? Ultimately, if we'll have a general court for, let's say, at least a decade, spanning 56 judges, and throw into the equation indeed the European Court of Justice with its 28, that in total there will be so many judges and so many replacements, so many vacancies also for advocates general, that, well, right now you have the 7-member panel. Whether that could really cope with the number of vetting procedures which have to be undertaken. I think there also an amendment is necessary on fairly short notice already.
Okay, from debacles to avalanche, now we're getting to... Freya, do you want to react on transparency
of appointment process? I don't want to stand in between people and their coffee, so...
Okay. Thank you for them then. And Andre, it's your turn.
Yes, so Professor Hirsch, thank you very much for this question. This actually, you've touched upon a very central point, my argument, which is I find that this relationship between this constitutionalist mindset and the need to defend sovereignty, for example, is a fundamental paradox of what I call this legal imaginary in Latin America. And you're right, during the 19th century, actually, the sense of unity and the idea to connect through a formal public law framework, for example, was also a reaction to eventual external interventions from Europe in particular. So we can see that from the letter circulated from Bolívar, for example, in 1822, to the other heads of states in Mexico, in Argentina, that he's actually referring clearly to that. We need to set ourselves as the new Americans, these new states, in opposition to Europe. And you can also draw that from a number of works written by these constitutionalists that I mentioned. In particular, for example, Alberti in his memories in memories in projects for an American Congress, he refers precisely to that. He says this is an opportunity to create a particular South American identity, to oppose ourselves in terms of identity to Europe, and also to guarantee that external interventions would be, in case of an external intervention, each one of us would support itself. So there was also this peace and security connotation to this idea of formally uniting in the public law framework. And what it's interesting is that this legal imaginary, I mean, this paradox is reminiscent still in the 20th century. I mean, but it takes on a different note, because now it's a reaction not only towards the United States, as we know, I mean, especially after the 50s, with the several direct and indirect interventions, but also vis-à-vis each other. So there are a number of small conflicts, and in a way, the argument of sovereignty is used also to protect one country from the other in the region itself. At the same time, there seems to be a relative agreement, for example, that there are shared values in the continent, which ultimately culminate in the, for example, in '38 in the Declaration in Defense of Human Rights, signed by all the states of the Pan American Union at the time, that will later also be installed in the OAS Charter, and then in '69 in the American Convention. So nobody denies that there is, in terms of values, this sort of, and in terms of rights, this sort of commonality between these countries. At the same time, when it comes to establishing how to deal with them by means of instituting power mechanisms such as courts or executive institutions, there is the problem. And there, in order to guarantee these rights, I think there's still much to be done and much to be agreed on, for example, in order to overcome this, so to say, this paradox, and be able to properly guarantee eventually all the rights that have been so far defended as common in the continent.
Okay, well, thank you very much for great presentations and papers and a very rich discussion. Now we have, I think, 30 minutes break up until, no, 20 minutes, okay. Up until then, probably 20 past 11, something like that. And we go for another round of 3 papers.